All right, we would away. The International Criminal Court is now in session. Lord John, the Court Panel International at 08. Please be seated. Vuyevu as well.
Good afternoon, everyone. Court officer, please call the case.
Good afternoon, Mr. President. Good afternoon, Your Honors. This is the situation in the Republic of Uganda in the case of the prosecutor versus Dominic Ongwen, case reference ICC 0204-0115, and for the record, we are in open session.
Thank you very much. I welcome everyone to this hearing. I would first like to state for the record that Mr. Dominic Ongwen, the legal representative of victims, Mr. Joseph Manoba, and his field assistant, Mrs. Listovel Atto, as well as the member of the common legal representative team, Mr. Walter Komakec, are attending this hearing remotely. I would like to thank the registry staff for securing their attendance through the use of video technology. I also thank everyone for cooperating in assuring the efficient conduct of the proceedings in this case. I would like to ask now everyone to introduce themselves and their teams for the record. We start with the legal representatives of victims.
Good afternoon, Mr. President, Your Honors. For the Common Legal Representative team appearing today, Mr. Orcholon Aransetseg, Legal Officer, Ms. Caroline Voltaire, Legal Officer, Ms. Ludovica Vetruccio, Legal Officer, attending remotely Walter Komakec, Field Assistant to Counsel, and myself, Paulina Massidda, Principal Counsel.
You step forward. These were the common legal representatives and the legal representatives now.
Thank you, Your Honor. Good afternoon. With me in the room, in the court, Mr. James Maguira, and you have already recognized those attending abroad.
Thank you. Long time no see. Welcome. Welcome again. Yeah. Then the defense team for Mr. Ongwen, please.
Good afternoon, Your Honors. Good afternoon, everyone in the court and attending abroad. My name is Thomas Alpoff, co-counsel for Dominic Ongwen, and here today in the courtroom is also the counsel, Chief Charles Achaleki Taku, and one of our assistant counsels, Mr. Gordon Jafudi.
Warm welcome to you also. We have seen each other every once in a while, but not in this courtroom. Thank you. Now we turn to the representatives of the VPRS and the registry. If none, that doesn't matter, then we turn to the Trust Fund for Victims, please.
Good afternoon, Your Honors. I'm Deborah Ruiz Verduzco, Executive Director of the Trust Fund for Victims, and I am joined by the legal team of the Trust Fund for Victims, Mrs. Francisca Eckelmans, Mr. Sheikh Fall, Mrs. Veena Suresh, and Mr. Marcelo Martoy. Thank you.
And in this instant, lastly, the OTP.
Good afternoon, Mr. President, Your Honors. Good afternoon to all colleagues. The prosecution is represented today by Ms. Ongyo Chong, trial lawyer, Ms. Marichel Rege, appeals counsel, Ms. Yasmina Suljanovic, and myself, Leonie von Braun, senior trial lawyer.
Thank you very much, and allow me also to present the chamber. My name is Bertram Schmidt. I'm the presiding judge of this chamber. To my right is Judge Peter Kovac, and to my left is Judge Chang-Ho Jung. We are accompanied by the members of our legal staff. I think not everyone here in the room. Some are also on the gallery. We gather today to pronounce the reparations order of this chamber in this case. As provided for by Rule 144, paragraph 1 of the rules, the chamber delivers a public summary of its main findings and conclusions, as we have heard in the beginning, in the presence of the convicted person, Mr. Ongwen, the defense team, the legal representative of victims, and the office of the prosecutor. Let me turn first to the scope of the case we are talking about. The chamber recalls that on the 4th February 2021, Mr. Dominic Ongwen a high-level member of the Lord's Resistance Army, LRA, was found guilty by this chamber of 61 counts, compromising crimes against humanity and war crimes committed in northern Uganda between 1st July 2002 and 31st December 2005. On 6 May 2021, the chamber imposed on Mr. Ongwen a sentence of 25 years of imprisonment. Both the conviction judgment and the sentence were confirmed by the appeals chamber on 15th December 2022. As specified in more detail later, the counts for which Mr. Ongwen was found guilty comprise crimes committed in the context of 4 attacks on the IDP camps of Pajule, Odek, Lukodi, and Abok, and sexual and gender-based crimes, as well as the crime of conscription of children under the age of 15 years and their use in armed hostilities. The chamber underlines that the present reparations proceedings exclusively deal with Mr. Ongwen's duty to repair the harm caused to the victims of the crimes for which he was convicted by this court. They do not extend to individuals beyond the victims of the crimes for which Mr. Ongwen was convicted. The chamber understands that individuals who have experienced harm as a result of the same conflict in northern Uganda, but are not entitled to reparations in this case, may be confused and disappointed. The chamber recognizes these individuals and acknowledges their suffering. However, it reiterates that reparations in this case are not designed to rectify all harm suffered throughout the conflict and are tied to the specific harm caused by Mr. Ongwen's crimes. These reparation proceedings, however, do not otherwise affect the rights of victims before national, regional, and/or international bodies. Now a few words on the principles on reparations. For the purpose of this case, the chamber adopts the principles as set out in the Taganda reparations order, as it considers them to be of general application. However, in addition, the chamber slightly amends the principles related to the types and modalities of reparations and child victims as follows. Regarding types and modalities of reparation, the chamber notes that, first, rehabilitation measures may also be aimed at improving the victim's socio-economic conditions. Second, payments that are not proportional and appropriate to address the victim's harm can only be regarded as symbolic and not compensatory. And third, measures of satisfaction and guarantees of non-repetition can also be included as appropriate modalities of reparations. Regarding child victims, considering the extensive manner in which children were affected by the crimes for which Mr. Ongwen was convicted, the chamber has adjusted the principles on reparations to the extent necessary to ensure that it includes, first, all victims who were children at the time the crimes were committed, or who were born as a result of such crimes, and second, the 4 principles of the Convention on Rights of the Child and the Child Right Approach. We turn now to the order for reparations against Mr. Ongwen. As determined by the appeals chamber, a reparations order must contain, at a minimum, 5 essential elements. These are, in short, the personal liability, the victims, the harm, the types and modalities of reparations, and the amount of liability of the accused. The Chamber will now detail its findings with reference to all those elements. First element is the personal liability. The Chamber notes that the Court's legal framework does not provide for any deviation from the principle of accountability. It clearly establishes that an order for reparations has to be issued in all circumstances against the convicted person. When appropriate, such an order for reparation can, in addition, be made through the Trust Fund for Victims. Accordingly, the present reparations order is against Mr. Ongwen to be made through the Trust Fund. The second element are the victims. This is a very extensive paragraph or part of this summary, better to say. In light of the type of reparations awarded, as we detail later, the Chamber establishes the eligibility criteria for reparations. It indicates the characteristics of the categories of eligible victims in order to enable their identification at the implementation stage. The Chamber stresses again that eligibility for reparations is to be determined by reference to the territorial, temporal, and subject matter scope of the crimes for which Mr. Ongwen was convicted, and not beyond that. With regard to the victims, we have to distinguish direct and indirect victims. First, direct victims. Natural and legal persons are eligible for reparations as direct victims if they can demonstrate that they suffered harm as a result of at least one of the following crimes. First, the victims of the attacks. Within the context of the 4 attacks against the IDP camps of Pajula on 10th October 2003, Odek on 29th April 2004, Lukodi on or about 19th May 2004, and Debok 8th June 2004, the following victims are eligible for reparations. Victims of counts 1, 11, 24, and 37, attack against the civilian population as such as a war crime. The civilian residents of and non-residents present at the IDP camps of Pajula, Odek, Lukodi, and Abok at the time of the attacks. Victims of counts 2, 3, 12, 13, 25, 26, 38, and 39, murder as a crime against humanity and as a war crime, civilians killed by the LRA in the course of the attacks on the IDP camps, including at least 4 civilians in Pajula, at least 52 civilians in Odek, at least 48 civilians in Lukodi, and at least 28 civilians in Abok. Victims of count 14, 15, 27, 28, 40, and 41, attempted murder as a crime against humanity and as a war crime. Civilians the LRA attempted to kill in the course of the attacks on the IDP camps, including at least 10 civilians in Odek, at least 11 civilians in Lukodi, and at least 4 civilians in Abok. Victims of counts 4, 5, 16, 17, 29, 30, 42, and 43, torture as a crime against humanity and as a war crime. Specifically, regarding the Pajula attack, hundreds of civilians abducted by the LRA and forced to carry injured LRA fighters and looted items, including heavy loads for long distances, while placed under armed guard to prevent their escape. Moreover, under constant threat of beatings or death. Some were tied to each other, and many were forced to walk through the bush barefoot or not fully clothed. LRA fighters beat abductees to make them walk faster. Regarding the Odek attack, civilians severely mistreated by the LRA during the attack and in its aftermath, thereby suffering instances of grave physical abuse, such as beatings with sticks and guns. One woman was raped with a comb and a stick used for cooking, while her husband was forced to watch. Civilians as young as 11 or 12 years old were also abducted and forced to carry heavy loads for long distances, some barefoot, while placed under armed guard to prevent their escape, and again under constant threat of beatings or death. Regarding the Lokodi attack, civilians severely mistreated by the LRA during the attack and its aftermath, and forced to carry heavy loads, some for long distances while tied together, and under constant threat of beatings or death. Civilians were also injured, raped, beaten, and mothers forced to abandon their children in the bush. LRA fighters threw small children, including babies, into the bush as they were crying and making it difficult for their mother to carry looted goods. And regarding the Abok attack, civilians severely mistreated by the LRA during the march from the camp through the bush, forced to carry heavy looted goods, and at least one injured fighter for long distances, oftentimes under the threat of beatings or death. Civilians were beaten as a punishment and to intimidate others, one forced to kill another abductee as a lesson to those thinking of escaping. Victims of counts 8, 20, 33, and 46. Enslavement as a crime against humanity. Specifically, regarding the Pajula attack, hundreds of civilians abducted from the Pajula IDP camp by the LRA. Regarding the Odek attack, at least 40 civilians, including men, women, and children as young as 11 or 12 years old, abducted from the Odek IDP camp by the LRA. Regarding the Lokodi attack, at least 29 civilians, men, women, and children, abducted from the Lokodi IDP camp by the LRA. And regarding the Abok attack, many civilians abducted from the Abok IDP camp by the LRA. Victims of count 9, 21, 34, and 47. Pillaging as a war crime. Civilian residents of the IDP camps at the time of the attacks, in light of the widespread looting of homes and shops in the camps, where LRA fighters took food and other property within the context of all four attacks, Pajula, Odek, Lokodi, and Abok. Victims of counts 22, outrages upon personal dignity as a war crime. Within the context of the Odek attack, one abductee forced to kill another abductee with a club and forced to inspect corpses. One abductee forced to watch someone being killed. And mothers who were forced to abandon their children on the side of the road, with one child being left in a rubbish pit. Victims of counts 35 and 48. Destruction of property as a war crime. Civilian residents of the IDP camps of Lokodi and Abok at the time of the attacks. In light of the destruction of several hundreds of civilian huts and household goods, including food stock and domestic animals. Victims of counts 10, 23, 36, and 49. Persecution as a crime against humanity. Civilians persecuted on political grounds because they were perceived by the LRA as being affiliated with or supporting the Ugandan government within the context of the Pajula attack, by an attack against the civilian population as such, murder, torture, enslavement, and pillaging. The Odek attack, by an attack against the civilian population as such, murder, attempted murder, torture, enslavement, outrages upon personal dignity, and pillaging. The Lokodi attack, by an attack against the civilian population as such, murder, attempted murder, torture, enslavement, pillaging, and destruction of property. And the Abok attack, by an attack against the civilian population as such, murder, attempted murder, torture, enslavement, pillaging and destruction of property. These were all the direct victims of the four attacks. We turn now to the so-called thematic crimes and start with the sexual and gender-based crimes directly perpetrated by Dominic Ongwen. Victims of count 50, forced marriage as a crime against humanity, specifically 5 so-called, I underscore, so-called wives at different times during the relevant period. Victims of counts 51 to 56, torture, rape, and sexual slavery as crimes against humanity and war crimes, specifically 4 so-called wives at different times during the relevant period. Victims of count 57, enslavement as a crime against humanity, specifically 3 women at different times during the relevant period. Victims of counts 58 and 59, forced pregnancy as a crime against humanity and as a war crime, specifically 2 women regarding 3 pregnancies during the relevant period. Victims of count 60, outrages upon personal dignity as a war crime, specifically 2 women at different times during the relevant period. Now turning to the sexual and gender-based crimes not directly perpetrated by Dominic Ongwen. Victims of count 61, forced marriage as a crime against humanity, specifically over 100 civilian women and girls abducted as so-called wives of male members of the Senior Brigade during the relevant period. Victims of count 62 and 63, torture as a crime against humanity and as a war crime, specifically over 100 civilian women and girls abducted by the Senior Brigade, subjected to severe physical and mental pain during the relevant period. Victims of count 64 to 67, rape and sexual slavery, both as a crime against humanity and as a war crime, specifically over 100 civilian women and girls abducted and so-called distributed to members of the Senior Brigade during the relevant period. Victims of count 68, enslavement as a crime against humanity, specifically civilian women and girls abducted by the Senior Brigade during the relevant period. These women and girls were no longer or not yet subject to institutionalized sexual abuse, but enslaved by being deprived of their personal liberty, restricted and dictated on their movement, including by threats, and subjected them to armed guard. They were subjected to forced labor and physical and psychological abuse. The next group are children born out of forced marriage, forced pregnancy, rape, and sexual slavery. The Chamber recalls its findings in the conviction judgment that the sexual and gender-based crimes directly and not directly perpetrated by Mr. Ongwen resulted in pregnancies. In line with previous jurisprudence, the Chamber finds that the children born out of the crimes of forced marriage, forced pregnancy, rape, and sexual slavery from which Mr. Ongwen was convicted, both as direct as an indirect perpetrator, qualify as direct victims. The harm they suffered was a direct result of the commission of these crimes. The last group of the direct victims, the child soldiers, victims of count 69 and 70, war crime of conscripting children under the age of 15 into an armed group, and using them to participate active in hostilities. Specifically, a large number of children under the age of 15 years abducted during the 4 attacks relevant to the charges, and generally between 1st July 2002 and 31st December 2005 in northern Uganda. They were assigned to service in the Senior Brigade, and they were all direct victims. We turn now to the indirect victims. Relying on the court's prior jurisprudence, the Chamber recognizes as indirect victims all categories identified in the Lubanga and Ndaganda cases. Accordingly, provided they can demonstrate to have suffered personal harm as a result of the commission of the crime against the direct victim, as well as a causal link between the harm and the crimes, indirect victims may include, first, the family members of direct victims; second, anyone who attempted to prevent the commission of one or more of the crimes under consideration; third, individuals who suffered harm when helping or intervening on behalf of direct victims; and fourth, other persons who suffered personal harm as a result of these offenses. In accordance with previous jurisprudence, indirect victims may include those who witnessed the commission of such crimes, insofar as their personal harm and the causal link with the crime is demonstrated. Regarding the family members of direct victims, the Chamber reaffirms that due regard ought to be given to the applicable social and familial structures in the affected communities. The Chamber subscribes to the understanding that, broadly, in the African continent, including in Uganda, the concept of family goes beyond the strict frame of a couple and their children. It includes their father and mother, brothers and sisters, and also other relatives. However, the Chamber underlines that the definition of victims emphasizes the requirement of the existence of a harm. Accordingly, family members, in the broad understanding of the Chamber, must always demonstrate to have suffered personal harm. This already leads us to the third element, harm. To define the harm caused to direct and indirect victims, the Chamber considered all relevant information before it. This included specifically the conviction judgment, sentence, the evidence submitted during the trial proceedings, observations by the parties and participants, and the information the Chamber obtained from its assessment of a representative sample of victims' dossiers. The Chamber notes that the evidence overwhelmingly demonstrates that entire families and the community of victims of the attacks on the 4 IDP camps as a whole, tens of thousands of individuals, suffered tremendous harm due to the unimaginable atrocities committed during and in the aftermath of the 4 attacks. We have spoken about that a moment ago in length. Similarly, over 100 women and girls and thousands of children, boys and girls, under the age of 15, suffered profound, multifaceted harm as a result of being kidnapped. Many were later subject to sexual and gender-based crimes and or forced to serve as LRA soldiers, being kept in captivity with cruel methods of physical and psychological coercion. The evidence shows that entire communities and families personally experienced the attacks, in which many of their family members, neighbors, friends, and others in their community were killed and severely mistreated. Houses were destroyed and burned, some with their residents still inside. Everything else, including all 8 food stocks, was looted or destroyed. Some civilians managed to escape the attacks, but most of those who survived were then forced to walk next to the bodies scattered through the camps. Civilians were abducted and forced to carry heavy loads of looted goods and injured fighters for long distances, while tied to each other barefooted. They were mistreated, which forced them to walk faster and prevented them from escaping. In some, they suffered great physical and psychological abuse during the walk out of the camps. The examples are distressing. Some were beaten to death, some were forced to kill other abductees, some children were taken from their mothers if they cried or caused their mothers to slow down. These children were thrown in pits and left to die. When reaching the locations of LRA forces where other abductees had been brought, women and girls were so-called distributed to LRA soldiers who subjected them to sexual and gender-based crimes and often held them in sexual slavery for a long time. Children under the age of 15 were integrated into the LRA forces. Some were kept for years, while others never turned home. As a result, the Chamber concludes that the direct victims of the attacks, the direct victims of sexual and gender-based crimes, and the children born out of those crimes, as well as the former child soldiers, suffered serious and long-lasting physical, moral, and material harm. The indirect victim of all these crimes suffered moral and material harm. In addition, the entire community of victims suffered community harm, and children of direct victims suffered transgenerational harm. The Chamber notes that due to the limitations that a summary imposes, it is not able to describe in more detail the great suffering and long-lasting consequences suffered by all victims of the crimes for which Mr. Ongwen was convicted. The Chamber notes, however, that acknowledging the victims' suffering, the reparations order recounts in detail the harm they suffered. This should also serve as a satisfaction measure in this case. I turn now to the fourth necessary element of a reparation order, the types and modalities of reparation. As to the type of reparations, based on the factors set out under Rule 98, paragraph 3 of the rules, the Chamber considers that collective, community-based reparations are the most appropriate type of reparations to address the harm suffered by the victims of this case. The Chamber wishes to make clear that collective community-based reparations refer to both the group that will receive reparations and the mode in which reparations will be delivered. With respect to the group that will receive reparations, the Chamber is referring to the community of eligible victims in this case. Of course, not the northern Ugandan community at large. Regarding the mode in which reparations are delivered, the Chamber is referring to community-based measures and programs that can reach large numbers of victims in a less resource-intensive manner. In the Chamber's view, the primary reason why collective community-based reparations are appropriate and necessary in this case is the extent of the harm suffered by the, and we can only stress that, by the overwhelming number of eligible victims, estimated by the Chamber to be close to 50,000. While the Chamber understands the desire for individual reparations, it remains convinced, for the reasons described in detail in the reparations order, that a collective award that addresses the entire community of eligible victims will ensure a more efficient, prompt, and practical approach. The extremely large number of victims would make an individual assessment of their harm for the purposes of granting individual reparations or collective reparations with an individualized component resource-intensive, time-consuming, and in the end it would be disproportionate to what could be achieved. Regarding the modalities of reparations, the Chamber considers that the only way to address the harms in a concrete, effective, and timely manner is through collective, community-based reparations focused on rehabilitation and symbolic or satisfaction measures. Specifically, the Chamber considers that the following modalities should be included. First, rehabilitation measures consisting of collective community-based rehabilitation programs directed at rectifying all types of harms identified by the Chamber, meaning the physical, the moral, material, community, and transgenerational harm. And second, symbolic and satisfaction measures, including a symbolic award of 750 euros for all eligible victims. The Chamber notes that the calculations of the amount of the award are explained in detail in the reparation order. And second, other community symbolic and or satisfaction measures. The Chamber also recalls that its detailed recounting of the harm suffered in the conviction judgment, the sentence, and this order serves as a satisfaction measure in this case. The Chamber is aware of and acknowledges the Trust Fund for Victims' limitations in terms of available resources. The Chamber therefore considers that prioritizations in terms of modalities and victims should apply. Regarding prioritizations of modalities of reparations, the Chamber considers that the payment of the symbolic monetary award should be prioritized over the rehabilitation and other symbolic measures. However, the Chamber is of course mindful of the role of the Trust Fund for Victims and its Board of Directors on the use of its so-called other resources. The Chamber will return to this issue later at the end of this summary. With respect to the prioritization among victims, the Chamber considers that first, priority should be given to vulnerable victims who are in dire need of urgent assistance. Second, priority should be given to vulnerable direct participating victims. Third, priority should be given to all remaining vulnerable victims. And lastly, all remaining known vulnerable victims should receive reparations. I'm turning now to the fifth and last necessary element of a reparation order, that's the amount of liability. First, a few remarks on the estimated number of victims. The Chamber considers it is not strictly obligated to identify the precise number of potential beneficiaries in the circumstances of the present case, where collective community-based reparations are being awarded. However, noting the recent approach of the Appeals Chamber of this Court, and in an effort to avoid lengthy litigation, the Chamber sets out in the reparations order its determination as to the estimated number of potential beneficiaries. The Chamber emphasizes that the figures are purely estimates, grounded, however, on the strongest evidential basis available to the Chamber at this moment, and for the purposes of assessing Mr. Ongwen's liability for reparations. Having resolved any discrepancies and uncertainties in the estimates provided in favor of Mr. Ongwen, the Chamber considers that the figures detailed in the reparations order represent conservative minimum estimates. They should also not be understood as a definitive determination as to the number of beneficiaries eligible for reparations, nor should they be seen to limit the number of potential beneficiaries who may come forward to be considered eligible to benefit from reparations. The Chamber estimates that the total number of potentially eligible direct and indirect victims of the crimes for which Mr. Ongwen was convicted, for the purposes of determining Mr. Ongwen's liability for reparations, is approximately 49,600 772 victims, and these include, as I said, direct and indirect victims. How the Chamber reaches this number is explained in detail in the reparation order. Now, some remarks about the amount of Mr. Ongwen's financial liability. The Chamber notes that in line with the Court's jurisprudence, in its determination of the total amount of Mr. Ongwen's financial liability for reparations, it has taken into account 4 key considerations. First, the type and extent of the harms suffered by the victims of the crimes. Second, the estimated number of potential beneficiaries. Third, the type and modalities of reparations considered to be the most appropriate in the circumstances of the present case. And fourth, the costs to repair the harm of the victims of the case in light of the reparations awarded. Having already addressed the first 3 considerations, the harm, the number of victims, and the type of modalities of reparations, I will now speak about the cost of repair. The Chamber reiterates that it has awarded, in the present case, collective community-based reparations focused on rehabilitation and symbolic satisfaction measures. Regarding the rehabilitation measures, the Chamber has considered the submissions from parties and participants, particularly from the Trust Fund of Victims, and resolved the discrepancies in favor of the convicted person. The Chamber estimates insofar that the cost of implementing the collective community rehabilitation programs ordered in the present case would amount to approximately 15 million euros. Regarding the symbolic and satisfaction measures awarded, the Chamber notes: as to the symbolic award of 750 euros, again, the calculation of which is explained in detail in the reparations order, the Chamber recalls that this is part of the collective community-based program. As such, it is awarded to the benefit of all eligible victims, without distinction as to their type of victimhood or harm. In order to calculate the amount required to provide this symbolic payment, the Chamber relies on its estimation as to the total number of victims in the case, which amounts to approximately 49,772 individuals, as I've already said. As such, the total amount required to provide victims with the symbolic payment is 37,329,000 million euros. As to the other community, symbolic and/or satisfaction measures, the Chamber considers it fair and appropriate to estimate the costs, which include inter alia apologies, ceremonies, monuments, memorial prayers, reconciliation ceremonies, and so on and so forth, at a total of 100,000 euro. In light of all this, the Chamber estimates that the total amount required to provide the reparations awarded in this case to the victims of the crimes for which Mr. Ongwen was convicted would be approximately 52,429,000 euros. The Chamber is satisfied that setting the amount of Mr. Ongwen's liability for reparations at an amount of 52,429,000 euros is fair, equitable, and appropriate, and takes into account the rights of the victims and those of the convicted person. Now, a few words about the implementation. Pursuant to the applicable legal framework, the Chamber instructs the Trust Fund for Victims to prepare a draft implementation plan, DIP, with the details of the rehabilitation and symbolic measures to be included within the collective community-based reparations awarded. The Trust Fund should submit the DIP for the Chamber's approval within 6 months from the delivery of this order. The Chamber instructs the Trust Fund to consult with the victims on the nature of the collective community-based awards, and the methods of implementation. The Trust Fund shall take into account victims' views and proposals when designing the proposed projects. As to the process for the administrative eligibility assessment, the Chamber has decided to adopt the eligibility process designed by Trial Chamber 2 in the Ntaganda case. As such, identification, collection of information, and eligibility assessment will be the responsibility of the registry through the victims' participation and reparation section. Outreach will also be designed and conducted by the registry to the Public Information and Outreach section, PIOS. The Chamber notes that no property and assets belonging to Mr. Ongwen have been identified to date, and accordingly, the Chamber finds him indigent for the purpose of reparations. Noting Mr. Ongwen's indigence, the Chamber also acknowledges that it would be for the Trust Fund's Board of Directors to determine whether and when to use its other resources to complement the reparations awarded in the present case. The Chamber encourages the Trust Fund to complement the reparation awards to the extent possible and engage in additional fundraising efforts to the extent necessary to complement the totality of the award. Nevertheless, the Chamber understands that in order for the Trust Fund to be able to fully complement the award, substantial fundraising will need to take place. The Chamber recalls that as soon as the Trust Fund is able to commence implementing the reparations awarded in this reparations order, which the Chamber acknowledges may take time, priority shall be given to the payment of the symbolic monetary awards over the rehabilitation and other symbolic measures. The Chamber also reiterates that considering the limitations in terms of available resources of the Trust Fund, additional priorities have been established in the reparations order. These imply that not all victims would receive the symbolic amount at the same time, of course not. Payments would be issued depending on the victim's urgent needs and vulnerability and the capacity of the Trust Fund to complement the award. As such, the Chamber underlines that victims cannot expect payments to be executed soon after the issuance of this reparations order. Moreover, in light of the convicted person's indigency, the Chamber acknowledges that there is the concrete risk that awards may not be paid if the Trust Fund does not manage to raise sufficient funds to complement the award. In light of this, the Chamber takes the opportunity to encourage states, organizations, corporations, and private individuals to support the Trust Funds for Victims' mission and efforts and contribute to its fundraising activities. Lastly, the Chamber would like to once again acknowledge the victims' suffering and express its concern and compassion for them. The Chamber also underlines its sincere hope that sooner rather than later, they will receive the reparations awarded in this order, allowing them to address the harm they suffered in a concrete, effective, and timely manner. This concludes the short summary of the reasons for this reparation order, which are explained, as I already have said, in much more detail in the order itself. At the end of this hearing, we turn now to the disposition of the order, which is also quite long, as you will soon recognize. For the foregoing reasons, the Chamber hereby unanimously adopts the Ntaganda principles with slight modifications regarding the principles related to types and modalities of reparations and child victims. Issues an order for reparations against Mr. Ongwen. Awards collective community-based reparations focused on rehabilitation and symbolic and satisfactory measures to the direct and indirect eligible victims in the case. Estimates the total number of direct and indirect victims in the case to be approximately 49,772 victims. Assesses Mr. Ongwen's liability for reparations at approximately 52,429,000 euros. Instructs the Trust Fund for Victims to prepare a DIP pursuant to the requirements outlined in the present order and submit it for the Chamber's approval by 3rd September 2024 at the latest. Invites the parties and the registry to provide observations on the Trust Fund for Victims DIP within 30 days from its submission. Instructs the registry through the PIOS to design and conduct throughout the duration of the administrative eligibility process the required outreach campaign for the purposes of these reparations proceedings. After engaging in consultation with the parties, the Trust Fund for Victims, the VPRS, the OPCV, and the country office, instructs the registry through the VPRS to conduct the identification of potential beneficiaries and eligibility assessments pursuant to the instructions contained in the present order, providing within 30 days from the issuance of this order an estimate as to the time it requires to assess eligibility and urgency regarding all participating victims. Instructs the registry through the VPRS to commence with the identification of potential beneficiaries as soon as possible and prior to the approval of the DIP. Instructs the VPRS and the PIOS to work together to ensure that the administrative eligibility process is completed within 2 years of the present order. Finds Mr. Ongwen indigent for the purposes of reparations at the time of the present order. Encourages the Trust Fund for Victims to complement the reparation awards and engage in additional fundraising efforts to the extent necessary to complement the totality of the award. And finally, encourages the states, organizations, corporations, and private individuals to support the Trust Fund for Victims' mission and effort and contribute to its fundraising activity. This concludes the Chamber summary and today's hearing. The Chamber wishes to thank again everyone, specifically the interpreters, the court reporters, and all other registry staff for facilitating this hearing. The court is adjourned.
All rise. We will